Okay, can you see my slides?
Yes, we can.
Okay, thank you very much, gentlemen, for the organizational assistance and also for the kind introduction. Now, let me begin by welcoming the participants. A pleasant afternoon to you all, and thank you so very much for making it to this final segment of the IP and Protection Workshop, which has been kindly organized by the GAP Summit of 2022. For me, it is indeed a privilege and a pleasure to have this opportunity to address such a brilliant group of the finest minds that we have, who are daring enough to be on this path of entrepreneurship to bring us new solutions to the problems that we face. Before I delve into today's content, we are going to have a discussion about how to protect your intellectual property as an entrepreneur, as a startup. But before we delve into the finer details of today's discussion, allow me to just give a brief background about myself and how I came to occupy today's very privileged position to be able to address you. As indicated, my name is Wayne Chinembiri, and I am born and raised in Zimbabwe to a family of 3 boys, of which I am the middle child. I studied for my Bachelor of Law degree in Zimbabwe, and soon thereafter, I completed a master's degree in intellectual property law at the University of Stellenbosch, which is in the Western Coast, the Western Cape in South Africa. As indicated, currently I work for Ericsson as a senior researcher in the IP, policy, and legal academic research division. I also work part-time for the Technical University of Munich, where I occupy the position of a research associate in the chair of intellectual property and corporate law. I am reliably informed, this is just a side note, that the Technical University this year, according to the QS ranking, has won the best university in Germany. And so it is indeed a great pride for me to be part of such an organization. So with that being said, allow me to emphasize at this juncture that it is neither in my capacity as a senior researcher at Ericsson, nor in my capacity as a research associate at the Technical University that I make this presentation to you today. Rather, today I will be putting on my cap as an admitted attorney of the High and Supreme Court of Zimbabwe, and also as an intellectual property law expert. I am also legally obligated to inform you all, or rather to reiterate 2 disclaimers. The first is that the views and the opinions that I will express throughout the course of this workshop are solely my own, and they do not necessarily represent those of my employers. The second disclaimer that I am obligated to make mention of at this stage in the workshop is that all the legal information that we will discuss throughout the course of the workshop is not intended to be taken as legal advice. The material and information and the contents of these slides, and also the web page of 4IP, is for general information purposes only. However, if you do need further clarity or guidance about what to do with your intellectual property, feel free to reach out to 4IP, and I will put the email address in the slides, and we will discuss a little bit more about the role that 4IP plays in supporting SMEs and startups to capitalize and commercialize their intellectual property. All right, so now that the formalities are out of the way, and now that all the protocols have been observed, let's move on to talk about the subject of the day. Something's wrong with my clicker. Okay. All right, so very briefly about us at Ericsson and what we do. Sorry, moving too fast. Okay. So very briefly about us at Ericsson and what we do. Ericsson is a Swedish telecommunications company, and it offers infrastructure, software, and services since 1875. So we have over 145 years of experience in the telecommunications industry. As you can see from the slide that is on the screen, Ericsson employs more than 100,000 employees, of which 27,400 of those employees are involved in research and development. We spend a total of about 42 billion Swedish korons in research and development, and that amounts to about 3.9 billion euros. And as a result, we have a very elaborate and a very strong patent portfolio of about 60,000 patents which have been granted around the world. And we have a presence in terms of our sales in more than 180 countries, and we make about 22 billion euros as a result of our sales. Now you will see how this information relates to the context of our presentation today as we go forward. So let's talk very briefly about the agenda for today's workshop. I will try by all means to kiss the workshop, and by that I mean to keep it short and simple. The problem is, intellectual property is a very wide field, and to be able to canvass all of the essential elements of the field within an hour is short of impossible. So I will try to move very quickly through the material that I have, but to give you a very clear picture of how you can use IP in order to boost the success of your startup, the success of your business, and how you can monetize those very brilliant ideas that you have. So firstly, we're going to look at exactly what is IP. We'll try to provide a definition of what IP is, and we'll also look at the specific types of IP that exist. We will also discuss what are the reasons it is important to protect IP. In other words, what benefits accrue to you as an entrepreneur for registering intellectual property rights. And finally, we will talk about how you can scale up your startup, how you can grow your business through use of intellectual property. All right, so before we get into the definition of what intellectual property is, I wanted to discuss a case study just to set the tone of the conversation, and so that we can all be on the same page about what it is we're talking about today. Now, it has been said before in the past, and I think one of the most recent persons who has raised this point to me was a colleague of mine, and he said, what a time it is to be alive. And for me, what I take home from that is the fact that we live in an information society now. So I will make a proposal and then I will pose a question to you. We now live in an information or knowledge society. And for me, what that means is that economic power and economic influence no longer rests solely in the hands of those who control material possessions. In other words, industrialists who own a lot of property, buildings, machinery, etc., are no longer the only people or entities that control or that are influential in terms of economic power. But in our generation, we have seen that people who control information, and in particular mental creations, have equally become important players when it comes to economic prowess or economic power. We also see that people who have managed to obtain legal rights to control mental creations have amassed a great and tremendous extent of fortune for themselves and for their companies. And so the question that we will be posing throughout today's workshop is, why is it so? Another study has shown that in the 1980s, a lot of companies could testify that on their balance sheet, 80% of the value of the company was in material assets, whereas 20% of the value in the 1980s was in intangible assets. But today, the complete opposite is true, because we see that most of the companies that are really successful, some of the Fortune 500 companies that we see today, 80% of their total value is actually in intangible assets, whereas 20% is in their physical material assets. So with that said, I'm going to call out a list of individuals, some of them very, very reputable and famous. And my question will be to you, what is it that you, the participants of this workshop, have in common with this list? So on my list, I have Bill Gates, I have Mark Zuckerberg, I have Steve Jobs, Steve Wozniak, I have Larry Page and Sergey Brin, Tom Ford, Steve Madden, Gucci Gucci, and Colonel Sanders. Now, this is a question to the participants. Please feel free to share and to participate and to ask questions if you have any throughout the course of the presentation. But we will also reserve some special time at the end to deal with more questions as well. So the question is, what do you think is a common denominator between the list of names that I've just called out and yourselves as the participants of this workshop? Unfortunately, I can't see my screen, so I can't see the participants, but
okay. So sorry to interrupt. Is everyone able to see the screen being shared here? It's written Ganymede Pharmaceuticals.
Indeed, that is what should be on the screen, just a blank screen.
So there are responses in the chat that I can see. Louisa talks about innovation. I can see, I mean, according to your question, right? And we have Wang Xing, who says it's great ideas. Brian says grit plus innovation.
Absolutely.
And Alejandro says sense of purpose. Okay. Belen says drive. That's what some of the responses have been from the participants. So I'm just.
Thank you very much for assisting me in that regard. And all the answers that have been given, the ones that I've heard, are correct. What is the common denominator between the participants and the list that I've called out is the commercialization of ideas. The only way that a startup can be successful is if it can manage to take an idea from just being an idea and then converting it into an actual product at the end of the day. And this is something that we see from the list of people who I called, is something that they have managed to accomplish. And so the purpose of this workshop is to draw your attention to the fact that intellectual property has continued to increase in importance. The importance of IP has grown exponentially over the past few years, and it is something that can be a tremendous asset to anyone who is going on this path of entrepreneurship, to anyone who is going to establish a startup. Because as we have already discussed, 80% of the value in some of the largest corporations today is actually captured in intangible assets. So I have a case study on the screen now about Ganymede Pharmaceuticals. I also now have a very lovely and cute couple as well on the screen. I don't know if any of you are aware of who this wonder couple is, but I will save you from guessing and provide you with the answer. This is Dr. Sahin and Dr. Turetsi. And these two lovebirds are the ones who established Ganymede Pharmaceuticals, a startup company, in 2001. Now, why is this important for today's session? The reason why I've chosen this particular case study to start off with is because it has immense value and it has a lot of, it brings a lot of encouragement to me, and it can bring encouragement to you too as a startup or as a potential entrepreneur, in the sense that in 2001, these two medical doctors established this company, and what this company has done or has contributed is that it focused on inventing an innovative class of cancer drugs addressing the treatment of solid cancers. The invention that they managed to obtain patents on was an ideal monoclonal antibody, or referred to as IMABs. And so what this treatment did was, it was a very unconventional way of dealing with solid cancers that affect the gastroesophageal tract. Now, in 2016, only 16 years later, this startup was acquired by a Japanese pharmaceutical giant known as Astellas Pharma, and it was acquired for 1.2 billion euros. Now, this is the really interesting part. At the time that this deal was closed, at the time that the deal went through in 2016, this startup company only employed 80 people. Just to try and typify the scale or the size, the magnitude of the company in question. So for me, this is a really touching and interesting success story of startups that manage to register their intellectual property and then monetize said intellectual property and flip the company for a lot more money than what was invested in it. I will also give a second example, which is a lot more familiar towards the end of the workshop. All right. So at this juncture, let us talk a little about what intellectual property actually is. Intellectual property refers to creations of the mind. Intellectual property can then be classified into different types of subcategories, but mainly intellectual property refers to the products of the intellect. And it stretches to cover things like inventions, it covers literary and artistic works, it covers designs, symbols, names, and other intellectual products that can be applied in the course of trade. But first and foremost, what is important to remember about intellectual property is that it is a property right. It is a lot similar to any other property that you own, in the sense that if you own property, you have the right to exclude other people from making use of your property. You can liken intellectual property to a bicycle or to a car, in the sense that if you do not give your consent for other people to make use of your property, then they cannot use it. They don't have an entitlement to exploit it. In the same sense, intellectual property is property. The only difference is that IP is intangible. It is immaterial. It cannot be touched, but it exists. So a lot of my students have a problem of conflating or confusing the intellectual property with the object that embodies it. So for example, I have a textbook here. So this textbook is physical property that belongs to myself. But in the same vein, the WTO and Peter van den Bosch own a copyright over the material that is in, or the way that the ideas in the textbook are expressed. So there is it is important for us to try and make a distinction between the physical object, which is the embodiment of the IP, versus the actual intellectual property, which represents the mental creativity of the person who has created this property in question. All right. So another thing which is absolutely critical to note about intellectual property is that intellectual property allows, it is a legal method which allows for a proprietor or a person who has invented or who has come up with a concept to be able to commercialize the idea and benefit from it. Intellectual property is designed to ensure that people who come up with brilliant ideas will be able to get some kind of financial return for investing in that idea. And investments are not only monetary, but investments can also be in terms of what you have invested intellectually or mentally. Intellectual property must ensure that an inventor or a creator gets a fair and an adequate return on the investment that they have made. So the amount of time that you have spent investing in an idea, trying to establish perhaps a startup that is going to bring a very disruptive technology, that time that you have invested in researching and in developing a product must needs be compensated. Because if there is no compensation for brilliant ideas, there will be no motivation for inventors to continue to think about the problems that we have and to bring solutions to the said problems. Okay, so let's talk about the types of intellectual property that we have. Now on the screen, I have a infographic document from 4IP Council. I'm not sure if it's very visible, but I'll just take you through very briefly, and then we'll focus a little bit more on each and every relevant type of intellectual property for startups and also for SMEs. So the first type of IP that I'd like to talk to you about is patents. Patents protect innovative technical solutions in all lines of industry. So a patent is an exclusive right that is granted for an invention. Intellectual property rights are territorial by nature. And by that, I mean that you apply for an intellectual property right in a specific country where you need protection. So in each and every country, there is legislation or there are laws that allow for the registration of patents and the registration of IP. And through this registration process, you then obtain intellectual property rights. So another way to put it is that most of the civilized countries, most of the countries of the world that we have today have patent laws in place. And so what it means for us in this workshop is that if you require patent protection in a certain country, an application for a patent needs to be made in that particular country. Once the application has been made, and if it is successfully granted by the patent office in that particular country, then you obtain the right to exclude other people from exploiting your invention or from distributing your invention in a commercial sense. A patent can protect a product, it can protect a process, and it can also protect a new chemical composition. The idea behind patent law is that we are trying to provide a patent right to an inventor in order to protect this new way of doing something or to protect the technical solution which has been invented by the inventor. The idea is that the patent owner or the patentee will be able to license the said patent Alternatively, to produce the goods that embody the idea, the novel idea. And by so producing the goods and excluding the competition from manufacturing similar goods, the patentee then enjoys a temporary monopoly on the market and then makes back the investment that they made into developing the idea and coming up with the final product as well. Generally, there are 3 requirements to be able to register a patent, which are that the invention in question should be new and innovative. In other words, it must not exist in the prior art. There must not be a similar invention, and this new concept must not exist in literature or in any other shape or form. Secondly, this patented good must be non-obvious. In other words, the idea that you have come up with should not be an obvious next step. Thirdly, the patented object or the subject for the application of the patent must needs have an industrial application. In other words, a patent cannot be granted over something which is of no use or which has no commercial or industrial application today in the society that we live. And of course, a patent can only be granted in respect of patentable subject matter, which means that in each and every country, there are certain things which can or cannot be patented. But we will talk about this in more detail. A patent is also valid for 20 years. And after this period of protection, where the patentee enjoys exclusive rights to prevent other people from manufacturing or distributing the patented goods, the patented goods become part of the knowledge that is embodied in the patented goods becomes part of the public domain, which means that competitors after the 20-year period are now free to also manufacture the said goods following that same process which was being used by the patentee. Okay, so another important intellectual property category that I would like to bring to your attention at this stage is copyrights or author's rights. Now, copyrights are a little bit different from patents in the sense that patents are protecting an invention, they're protecting a thing, a process, or a new chemical composition, whereas copyrights are now protecting the creative aspect of human contribution. So we're talking about things like books, we're talking about music, we're talking about plays, we're talking also about computer software, except in the United States, a large majority of other countries, in order to protect a computer program or software, you need to make use of copyright. Basically, protect artistic works, strategies to cover movies, works, plays, broadcasts, and a wide range of other artistic things like sculptures, painting. On the screen, the infographic also shows that even audiovisual works as well can be protected. So if the really interesting thing about copyrights is that you don't need to make any formal registration process in order to obtain a copyright. A copyright automatically subsists, or you automatically get a copyright as an author or a creator the moment that you publish your work. The moment that you have a finished product and you publish it to members of the public, you automatically have a copyright in the said work. So let's also talk about trademarks, because trademarks are one of the very fundamental ways that startups can protect their ideas, can protect their investment in their business using a very limited amount of resources as well. Now, a trademark is a type of intellectual property that protects, or rather it is a it is a version or a type of IP that protects distinctive logos and distinctive products. A trademark basically is a sign that is capable of distinguishing the goods of one producer from the goods of another. So a really relatable example that comes to mind is the trademark of McDonald's. And immediately when you hear of McDonald's, you associate it with fast food. But what is important is you can distinguish the fast food offering from McDonald's from the fast food offerings from different places, such as Burger King. Both of these two entities have got registered trademarks over their goods, and this really assists consumers to be able to distinguish and differentiate between the offerings of either company. And this is what is particularly important about trademarks, because trademarks help startups and SMEs to establish a brand and thereafter to be able to protect their brand. And we will also talk about how trademarks facilitate for brand protection in the coming slides. Trademarks, however, are wide enough to also protect things like shapes. For example, the shape of a Coca-Cola bottle or the shape of headphones. If, for example, you have headphones that have got a very distinctive shape that you are proposing to produce as a startup or as a small to medium enterprise, you can obtain trademark protection for the shape of goods as well. Trademark protection extends to cover things such as color combinations as well. Not only color combinations, but also slogans or trademark protection is wide enough to protect sound as well. Certain sounds, like for example, the Windows log off, can and has been protected using trademark protection. And so trademarks are a very inexpensive way of securing any unique ideas to which trademarks apply. And they're very valuable, as you will see, for combating counterfeiting, but we will deal with this in one of the slides that will follow. Apart from trademarks and copyrights and patents, we also have designs, registered designs, and trade secrets. Registered designs protect the shape of the goods that you produce as a business or as an individual. And what we have noted with time is that the design or the shape of a product is such that sometimes it has an aesthetic purpose or a functional purpose. For example, the shape that can be applied to a pair of headsets, or the shape that can be applied to the body of an automobile, of a motor vehicle, is something that you would seek to protect using a registered design, because it is very different from what already exists on the market, and also because it is very attractive. As you will see when we discuss designs in more detail, when you are selling goods to consumers, the appearance of goods is extremely important as a unique selling point as well. So if you can obtain design protection for the shape of a motor vehicle or for the shape of a certain product, for example, this clicker that I have in my hands, it can be designed in such a way that it's very comfortable to hold and it's very easy to toggle with one finger. That particular design can be protected using registered designs. And so this can give you a competitive edge over your competitors, in the sense that competitors cannot manufacture anything that looks remotely similar to this. But we will talk about that as well in an ensuing slide. And finally, we have trade secrets. Trade secrets are confidential business information which is providing a commercial benefit to a business. So it can cover things like client lists, it can cover things like manufacturing processes, it can cover a lot of different types of material, such as training manuals, which may have been developed by a company in order to assist its employees to be able to sell goods, perhaps to the customers. There are other intellectual property rights as well that are not going to be the subject of this workshop, such as geographical indications, which cover the source origin of goods. For example, when we talk about geographical indications, we can talk about products such as champagne and cognac, which are basically sparkling wine and brandy, but because they originate from a specific region on the face of the earth, they then obtain a special protection. This is because the people who manufacture these products in these particular regions attest that these products have got superior qualities owing to the fact that they grow in that particular region. We also have plant breeders' rights, which are rights and entitlements that are provided to the people who are responsible for developing new plant varieties and new cultivars. And we also have, which might be of interest to you in today's workshop, we also have the sui generis, or the special protection for databases. A compilation of information in such a way that it creates a database can be protected as well at law. And this is called the sui generis, or the special data protection. Okay, but unfortunately, these will not be topics that we cover in today's workshop because it will be outside the scope of the discussion. However, if you do wish to take a look at a more interactive version of this slide on the types of IP, I encourage you to click on the link to 4IP Council, where you will find all this information and more. Okay, so now let us talk about the benefits that arise, or the benefits that accrue to registering a patent. Okay, so the first reason that I would advance for registering a patent is market access. Market access refers to your ability as a startup to be able to access consumers on the market. Registering a patent allows you as a patentee to have that freedom to operate within the market without having the fear that your inventions or your products that you are selling are infringing on products of other people. In another sense, we also refer to a certain type of company or a certain type of business. This is a business model that can be attractive to startup companies, and it is called the non-practicing entity. And what a non-practicing entity is it is a business that produces technology but is not involved in the manufacture and distribution of the said technology. So as a startup, most of the time you have a very innovative idea that you've come up with, but sometimes you do not have the resources that are necessary to commercially exploit the said idea. Alternatively, the competitors in the field are the ones that have got manufacturing capacity, and they also have established marketing channels. As a result, patents allow an SME to be able to adopt this NPE, or non-practicing entity approach. And this is whereby an SME comes up with an idea to produce a certain very innovative product, but instead of this SME then investing or looking to find investors to begin manufacturing the said product, they can license the patent which embodies the idea to a competitor. And the competitor often has the capacity to produce the goods. The competitor has an established market as well. And so instead of the SME or the startup having the burden or the obligation of then going to look for investors and to develop these products and sell them to the public, all that you would have to do as a startup with a valid patent that has been registered over an idea is to approach a competitor and then to enter into a licensing agreement in terms of which the competitor is now the one that is producing the good and distributing it through established markets. Secondly, patents really boost the sales of a said product in the sense that certain empirical studies have shown that consumers attach a high value to products that they believe or that they have learned are patented products. As I said in the previous slide, when you're dealing with the market, it is one of the most important factors to consider is how the product is being perceived by members of the public. And so if perception is a very important selling point for consumers to know that the product in question is patented, is something that can really help to boost the sales of the said product. And finally, patents are also very important for enabling negotiation. Patents enable negotiation in the sense that most of the time you find that other competitors in the same field have patents already on similar technology or related technology. What having a patent portfolio means is that you can sit down at the table with your competitors and you can have a very balanced kind of negotiation with your competitors in the sense that it's most likely that the technology that you have a patent on is also being exploited in one way or another by a rival company. Alternatively, patents really facilitate a conducive environment for negotiation and cross-licensing. And by that, I mean, perhaps your startup has come up with a very brilliant idea, which you have patented, which has not previously existed, obviously, within the field that you're operating. Your competitors may want to exploit this technology, and they are more than willing to sit down at the table with you and have a discussion of how you can collaborate and cross-license each other's patents in order to produce even more innovative goods. If, as I assume, the technology that you wish to bring to the market is very innovative and is completely disruptive, this type of technology can be accepted or it can become a standard technology. In that event, you also have the opportunity to sit down at standard development organizations. You have a seat at the table and you can negotiate and you can discuss how this technology should be implemented into the standard and become part of, it becomes a very successful technology because of that standardization. In addition to the reasons that we've already discussed, we have funding and strategic value. Now, I was very privileged last week to be able to attend a course which was being offered here at the Technical University on private equity funding and private equity investment. And one of the things that emerged from our discussions during this seminar was the fact that patents are a very attractive asset for venture capital and also for public funds as well. This is because, as I indicated, there is a shift in perception now from looking at tangible goods as the only type of asset that a business can own to looking at intellectual property as an equivalent asset that can be monetized. And so if a startup already has patents or any other types of IP, this is a very strong selling point. It's a very attractive feature to have, because by virtue of this feature, you can attract that funding, you can attract that venture capital as well. In addition, you will see from the example that will come at the end of this workshop that having intellectual property is something that is a very attractive feature once you decide that the startup is going to go public. Once this private company that is registered and that is the proprietor of certain IP decides to become a public company, intellectual property is something that is listed in the initial public offering documents. And you will see from the example that we will discuss at the end of this workshop that it's something that can make your company to become very attractive and increase the share price as well. In addition to the points that we have discussed, of course, I would like to just briefly touch on strategic value. Now, registering patents is important because it enables businesses to be able to perform what we refer to as strategic turnarounds. Startup companies can adopt a turnaround approach in the event that they feel, maybe you feel that the market is too saturated or there are too many competitors. It is very easy for a startup that has patents to shift from being a startup that was in the production of goods to become a technology licensing company. And we have seen that with a lot of examples as well in the real world, where a company that was involved in producing certain goods decides to refrain from producing these goods and then just license technology that it has developed. This is actually true also of Ericsson, in the sense that I'm sure some of you might have owned a Sony Ericsson phone at some point, a Sony Ericsson handset. And at some point in time, Ericsson was involved in manufacture, of course, in collaboration with Sony. Ericsson was involved in the manufacture of handsets, mobile handsets. But then at some point, as a company, we decided that it would be more valuable for us to focus on research and development in creating new groundbreaking technologies to deploy. And what we now do is we license the said technology to third parties and to other companies who then go on to implement this technology. And we get our revenue, we derive our return on our investments in R&D through licensing revenues and licensing and royalties that flow from these licensing agreements. And we invest a large proportion of this money back into research and development so that we can continue to be an innovative and disruptive company. Okay, so let's talk very briefly about some of the benefits of trademarks. As I indicated in the beginning of our discussion, trademarks are a source indicator. They are a badge of origin. Trademarks can also be regarded as a guarantee of quality. When you see the trademark of a certain company on goods, you can assume, you can rest assured that the quality of this product is the same as the quality of the same product that bears the same mark. In other words, if you buy a product from Decathlon, you can be assured that the quality of this product is very similar to the quality of a product you will obtain in a Decathlon in France or in a different country. So trademarks go a very long way in announcing where a product is made and also in declaring the standard or the quality of the said product. Trademarks are important because they will prevent your competitors from being able to benefit from the good reputation or the brand value that you have created in your product. Trademarks protect names, slogans, color combinations, domain names for the internet, sounds and smells as well. So trademarks are important for differentiation so that consumers can tell the difference between one product and another. Trademarks protect your brand from free riders and people who would like to produce counterfeit goods. And this is important because we see that a lot of brands have their reputations ruined because of counterfeit goods. It would also interest you to know that you can only prevent counterfeit goods from entering into the borders of a certain country if you have a registered trademark, because the customs officials of a certain country can only prevent goods from entering the country if you, as a registered trademark holder, make a complaint to customs. Without a registered trademark, you would not be able to get customs to implement border controls to prevent goods from crossing from one country, counterfeit goods, from crossing from one country into a country that has your target market. Trademarks help to build a reputation, and they help you to protect your brand value. And finally, trademarks also help to boost your revenue. And one of my professors from South Africa always gave a very vivid example of how trademarks help to protect, to build revenue or to get access to funding. And my professor used to say, imagine that the Coca-Cola company today lost all of its manufacturing plants, it lost all of its tangible assets, and was only left with its trademark, Coca-Cola. Do you not think that it could take this trademark, this registered trademark, to the bank and use this trademark as a security, as collateral to be able to obtain loans to restart its business? It is indeed possible because the Coca-Cola brand has gained immense reputation throughout the years, and it is therefore, it can be related to as a tradable asset in one way or another. Okay, I'll try to skip through so that we can at least get to the case study at the end. As I said, if I am unable to completely canvass all the aspects I wanted to discuss with you today, I will be making these slides available through the organizers, and each and every page of the slides has a link to relevant material, which is very easy to understand from 4IP Council. Now, very briefly, copyrights, as I indicated, are also referred to as author's rights. They protect the creative and the artistic expression of your startup or of your SME. And they give a competitive advantage because they provide a much lengthier protection. So basically, copyrights can exist or copyrights continue to exist as an exclusive right at least 50 years after the death of the creator. Copyrights also help to increase the reputation of a company, and that is the reputation for creativity. Copyrights also offer an opportunity for collaboration in the sense that you can collaborate with other business partners in order to bring your products to a wider market. An example would be the Walt Disney Company, which in 2018 made $54 billion from character merchandising. So Disney characters were being, the right to use Disney characters was licensed to other players who then produced t-shirts and other consumer goods. And as a result of these character merchandising, Disney made $54 billion in 2018. And of course, copyrights can assist you to obtain venture capital funding as well, to the extent that these copyrights protect, for example, training manuals and other client lists that you may have. Okay, so very briefly on designs, again, you will see that a lot of these rights that we're discussing have got similar benefits. Exclusivity, meaning that you can exclude other people from copying the design of your products and from exploiting it in a commercial sense. Commercialization is another benefit in the sense that you can license design rights to other players so that other parties can produce goods with a similar shape or with an identical shape to your products. And of course, collaborations as well under the commercialization heading. Again, design rights allow you to build a reputation for products that have got a very nice aesthetic visual. And design rights allow you to tap into value in the sense that design rights allow you to attract venture capital. They also allow you to access public funds. For example, the European Union also has a fund that supports SMEs and startups, but a really an added advantage that you can have in order to apply for this funding is to have some kind of registered intellectual property, and design rights are recognized as one of these intellectual property rights that can help you to get funding. Okay, so now we move to a brief discussion of trade secrets. Now, as I indicated, trade secrets are confidential information that is held by your startup or by your business that has not been disclosed to the public, and that brings you some kind of commercial benefit over your competitors. Very briefly, trade secret protection is important because it is of unlimited duration. This is different from patents. The disadvantage with patents is that they only last 20 years, whereas trade secret protection lasts indefinitely as long as the information remains a secret. Secondly, this is another benefit of trade secrets over patents. Patents are more expensive to register, and this is a disadvantage, of course, albeit patents are more secure. But trade secrets are very cheap because all you have to do is to create a framework for protection of trade secrets within your company. There is no formal registration process that is necessary for registration of trade secrets, and there is legal protection in the form of unfair competition, in the form of common law protection or protection arising out of cases that have been dealt with, and also in the form of legislation. But this will depend from one country to another, how trade secrets are protected. So trade secrets will also protect you from breach of contract. Let's say you have some employees who know of trade secrets within your organization. You can use trade secrets to prevent your employees from leaking information to competitors. You can protect your startup and your innovative ideas from the risk that your employees might try to steal your ideas and establish their own competing companies as well. So trade secrets are very important in that regard. Trade secrets can protect algorithms, formulas, recipes, client lists, methods of doing things, and marketing plans as well. So just to consider on trade secrets, I have some information on the slide as well, also available on the 4IP website. Okay, so the final segment of our presentation for today is IP for business growth. And as you can see from the slide, IP can be a very lucrative asset because when you have IP, you already have an asset which you can use either to source funding or an asset that you can develop further on by investing in research and development on that particular asset. IP is like a tree, as you saw in that example, in the sense that it takes from you, from your creativity, and then it gives to the world. But then the fruits that come from the tree also allow you to be able to generate more revenue, which you can then invest back into the business. So the final case study that I have for you today is Biotech. Biotech was founded in 2008, again by Dr. Sahin and Dr. Turetsi. And this is, Christoph Huber as well. And this is one of the examples of a very, a company that is heavily reliant on intellectual property, on patenting, etc. And in the notes for this slide, I managed to get an excerpt from their public initial offering where they were discussing their intellectual property. And one of the important things that they said, I won't be able to cover everything that they indicated, but they did say that as a company, they have broad mRNA expertise, and this is their core strategic asset as a company. This mRNA technology that they use to create spike vaccines, such as the Pfizer-BioNTech on the screen, is protected by a global patent portfolio and also by trade secrets. This is according to their declaration in their initial public offering that they made in the United States. The company was started with 150 million of seed investment, but as of 2021, it was worth 18 billion euros. This is 126 times more value than what they put in at the beginning. This is the result of the heavy investment, the heavy reliance on intellectual property. And I truly believe that IP can be something, it can be a game changer for us in this journey to produce very innovative goods that can change the way that we deal with the problems that we face in our everyday lives. I see that I'm over the time that I have, but if the organizers will allow me, I would take one or two questions as they wish.
Okay, thanks, Ron, for the informative presentation. We do have a couple of questions from the chat section. So maybe I will facilitate by asking you the questions. So the first question asks you how the patent process works in university. Basically, we as a student working at the university, and does the patent belong to the researcher or the university? How does it work?
Okay, that is a very fantastic question, and thank you for asking it. Universities have got IP policies, and this may differ from university to university, but in my experience, the IP policy of the university requires students, research associates, and other employees of universities to assign their inventions to the university. In other words, the university is the proprietor or the owner of the IP right, but in exchange for that assignment, in exchange for giving your intellectual property right to the university, you will also obtain some kind of financial consideration. There is some kind of payment which will be made to you depending on university policy. And you will definitely be remunerated or compensated for coming up with this idea. But the reason why universities take IP and hold it as their own is because, for the most part, if you are a researcher or if you are working for the university in some capacity and you come up with something, an innovative idea or a patentable product, the situation is that most likely you have produced this IP during the course of your employment or using resources that belong to the university. So the university does have a right to own the IP, but most of the time, and this is, I think, almost 98% of the cases, that there is some kind of compensation which comes to you as the inventor as well.
Okay.
I hope that adequately answers.
Yeah. So maybe I will move to the next question as well. There are questions coming up in the chat section. So someone wants to ask about how do we know if we should get a patent or a trade secret? So what is the difference basically in which situation?
Fantastic question as well. And it's absolutely relevant to you, of course, as entrepreneurs, as startups. And the truth of the matter is that both have pros and cons. Now, as we said, patents offer some of the most benefits when it comes to truly securing your right against imitation, against copying, and against free riders. In the sense that for a 20-year period, in countries where you have obtained a patent, no one is allowed to either distribute or to reproduce or to manufacture a good that is covered by the patent. The downside, of course, is that patents are most likely the most costly of the intellectual property categories that we've discussed today. When it comes to registration, patents are a bit more costly, but they offer the greatest and strongest type of protection. When we look at trade secrets, on the other hand, trade secrets, you virtually pay nothing because you don't have to pay for registration with a patent, an intellectual property office or a patent office. So you can automatically start protecting your trade secrets as you are by yourself without having to approach any office or having to list your trade secrets within an official register. So what I would say is that it will really depend. It's difficult for me to give an answer that covers all different types of investments. So I would say maybe a fair way to respond to this question in a more personal way would be to say, I would invite you to get in touch with us, with my collaborators from 4IP Council via email, and then we can help to make an assessment of whether or not the type of invention or technology that you are intending to bring to the market is one that should be patented or not. But either option offers pros and cons. With trade secrets, there is not much security in the sense that once a trade secret is known, then it is no longer possible to protect it using trade secrets. So patents are more secure, but more expensive. Trade secrets are very cheap, but do not give you a very strong type of protection.
Okay, there are questions coming up. Maybe we have to stop because of the interest of time, because we are already 1 hour and 10 minutes. So thank you for your questions. And if you have any questions, you can ask later through emails as well, or you can ask here right now, speaking up. That may be the last question for the interest of time. Okay, so if anyone wants to speak up, or we can take it later as well. Okay, so it's already been 1 hour and 10 minutes, and I'm sorry that I couldn't take up all the questions. There have been many other questions. So
I actually just asked the question in the questions section, if it's possible to read it, or
Okay, so you can speak it here as well. Yeah.
Yes, please. I cannot read anything on the chat because I don't see any of the participants, unfortunately, but please feel free to ask.
Okay, so my question is, what if we bring up a new solution under the framework of a certain program, which actually by applying to that program, there has been some conditions saying that the ideas developed will belong to the company offering the program. Should the team in this case still do the patent, or it actually belongs to the program, so the team cannot do that?
Okay, that's a really interesting question that you pose. I would say, from a lawyer's perspective, I would say it depends. It depends on how much of the resources of this program have you used. Have you developed this new or technical solution on the basis of material that has been provided by the program as well? So if you answer yes to the last question, and you also answer yes to using material or resources of the program, then to a certain extent, this IP also could be co-owned or could become part of the property of the program. If this is an idea or a technical solution that you have independently developed as a team without using the resources of the program or the institution for which you work, then this is a different story, because you have produced this intellectual creation by yourselves, and therefore it would be probably a good idea for you to establish your own company and then register this idea under that company. But like I said, it depends on the extent to which you have relied for support on the institution that you are referring to or speaking of.
Yeah, I see that. Thank you so much for your answer. Actually, it's a little bit complicated for this case. If it's possible to ask you again this question on private to actually give you more details about the situation, if possible.
Indeed, as I was saying, the difficulty that we have is that we have a wide variety of participants with different types of inventions. So I cannot really give you a one-size-fits-all, but please feel free to get in touch with us, with our collaborators, 4IP Council. It's a European not-for-profit organization, a research council that is dedicated to developing high-quality academic insight and empirical evidence on topics that are related to IP. So they will definitely provide a lot of support. I have put the email address as well on one of the slides and in the notes. So feel free to get in touch with us, and then maybe a more detailed conversation can be had.
All right, thank you so much.
Pleasure.
Okay, so that's it for today's session. Thank you everyone for joining. We'll be sharing all the slides as well as the recorded session with you. So, okay, have a very nice good evening or morning, whatever it's time there.